right, the next case on the calendar is Kendall Cobb versus the state of Florida. Counsel, how much time would you like for rebuttal?
3 minutes, please.
3 minutes? Okay, whenever you're ready.
May it please the court, my name is Ed Weiss. I'm here on behalf of the appellant, Mr. Kendall Cobb. Mr. Cobb was originally charged by the police of lewd and lascivious molestation and 2 counts of lewd and lascivious conduct. The state attorney, for some reason, changed count 2 to lewd act upon a child, something the state has conceded hasn't existed since 1999. Thus, count 2 was a non-existent offense. He went to trial. A judgment of acquittal was granted on count 3. The jury acquitted him of count 1, but found him guilty as charged on count 2. There were no lesser includeds, and it's unclear in the record if defense counsel even asked for any, but it was clear that none were given. Thus, the jury found Mr. Cobb guilty of a non-existent offense. The issue today isn't so much whether that's a violation of due process that has been conceded by the state. It's what the appropriate remedy is. And what is being argued by appellant is that the appropriate remedy is that it is to be remanded to any properly charged offense that is contained within the information, and that is an unnatural and lascivious act, a second-degree misdemeanor. To simply say it should be remanded and allow the state to amend the information to reflect a proper felony would be a violation of double jeopardy, because you're allowing the state to change the charge dramatically to accommodate a felony. That is not proper once a jury has been sworn and tried and convicted of. Therefore, we have to look at the information and what charge is properly alleged in the information. As the Supreme Court stated in INSCO, age is a necessary element of basically all sections of 800.04 except for the one which requires sexual activity, which is not alleged in the information.
The 800.02, the second-degree misdemeanor, isn't that a lesser?
Ironically,
if it's a lesser, then why wouldn't Gibson simply say because it was not asked for or instructed that your client just basically gets an acquittal?
I mean, if this court wants a straight acquittal, I'm fine with that as well.
Well, it's not a want or not want. It's
well,
a matter
I understand.
Yeah, you kind of, your first argument was that there's no lesser, you suggest there was no lessers, and I agree with that. And it seems that the Supreme Court has said when you're convicted of a non-existent crime in Gibson and no lessers are given, that you can't go back and try the lessers here. So,
I mean, I would agree with that. The concern also is waiver. This court has recently found that waiver can exist where counsel just accepts things, and in this case it does appear that counsel did accept them. But the concern is the clear improper remedy is a new trial, is allowing the state to be remanded, amend the information, and give the defendant a new trial on an amended information, now charging a proper felony. And that clearly is erroneous. That's contrary to what the Supreme Court held in Gibson. It's contrary to what the Supreme Court held in Merritt.
But your argument is that the information properly charges a natural and lascivious act, and that the evidence that was introduced at trial was sufficient for that.
Would support the verdict. And I concede to that. I'm not going to sit here and try to tell the court that that isn't there. That's disingenuous. I'm not that person. I think it does
your client's already served 60 days, I assume.
Actually, Your Honor, he was originally sentenced to nearly 5 years. A motion to correct was filed. It got reduced. He's actually already out of prison and is currently serving his probationary sentence. The other concern is we live in a society that everything's published online now. He's required to register as a sex offender, and he has to register for the rest of his life. I apologize. I turned this off. I turned that off. He has to register for the rest of his life. So now we have a situation where he's illegally having to register as a sex offender for the rest of his life. He has 10 years of probation on a non-existent offense. And we would ask that this court reverse and remand an entry in order in which it is either a full acquittal or at the most conviction of a second-degree misdemeanor unnatural and lascivious act. And I see I have 10 minutes remaining. I'll reserve the rest and save my voice.
If you want to do that third case.
Okay, all right.
May it please the court, counsel, good morning, Kelly Nealon again. It's our position that there is no double jeopardy bar to a retrial in this case. In fact, double jeopardy was never even argued by the appellant.
Well, you concede that there were no lessers given,
Correct.
and you concede that he was convicted of a non-existent crime.
Correct. Well, a no longer existing crime. It was at one time. But he was.
My problem is that my understanding is that the Supreme Court said that lesser offenses not presented to the original jury can't be prosecuted by the state after a conviction has been vacated on the basis of a non-existent crime. The Supreme Court said that in Gibson. And so I don't see how you get a second crack at the apple here.
Because he was not acquitted of any of the elements of the crime.
Well, there was no crime. There was no crime charged. That's the problem. Jeopardy attached. The jury was sworn, and apparently the state attorney and the trial judge didn't realize that this particular offense hasn't been on the books since 1999.
But he never objected to it. He was convicted of, the jury found those elements.
But even, I mean,
That-
if I'm looking at the Fredericks case out of the first DCA, and it cites this, I mean, conviction of a non-existent crime is fundamental error mandating reversal even when the error is invited by the defendant. Or
Yeah, I'm not
as was in this
disputing
case,
it's
by request
reversible.
for a jury instruction on a non-existent offense. So, I mean, even if, so I don't think it makes a difference whether defense counsel raised an objection to it or not. I mean, it appears to me that you cannot be convicted, regardless, you can't be convicted of a non-existent offense.
That's true. I don't disagree with that, but then the issue is there a remedy, and what is it? And it's our position because there was not an objection to it, because if he would have objected, the state could have amended the information at any point in time. The element that was missing was age, which would not have prejudiced him in any way. He gave a statement, admitted his age, he admitted his age when he was testifying. It's not like, the dates were changed to make her younger or to make him older or something. I mean, this is something that, if there had been an objection, then it could have been remedied right away. And in that Aiken case, the Florida Supreme Court said that the defendants can't just do a gotcha, just stand by and watch error occur and then benefit from it. This case this court in Moore, I mean, he was convicted of a...
That presupposes that the defendant was any more aware of the error that was occurring that apparently the state and the trial judge. Why should we assume that the defense was somehow more clever than the state and the trial judge, who apparently let this thing go by without any problem at all?
Well, I'm not assuming that at all, but he is arguing it.
And that, this shouldn't be a game of gotcha, but, why should we indulge ourselves that they were somehow more clever than the other parties who may have been not so clever?
I don't think you have to indulge in it. I'm not even saying that maybe they were playing a got you. But the fact that it did happen and now they've challenged it on appeal is I mean, that's the whole underlying current of the contemporaneous objection rule. Maybe you don't know about it, but you still have to object to it.
Well,
and that's
not if it's fundamental error. I mean, you've conceded it's fundamental error.
Correct.
Why doesn't that bring the conversation to a close?
because even when fundamental error occurs, there has to be a remedy for it. The defendant can't
Not
just,
if there's
the defendant doesn't just walk away every time there's fundamental error.
Monaco said one time, "Don't interrupt me when I'm trying to interrupt
I
you."
apologize.
So, isn't double jeopardy the problem, though? I mean, if jeopardy attached, I agree if this was, you know, a non-fundamental or a non-double jeopardy problem, you might get a second shot. But if we conclude that it's a double jeopardy issue, then aren't you out of luck under the Supreme Court's authority that says, particularly where there were no lessers given?
Well, first, like I said, I don't ever remember seeing the words double jeopardy in any of the briefs. And in the Florida Supreme Court's Wilson case, they say retrial on a lesser offense doesn't present a double jeopardy problem, which here, no, there weren't. But it's because the United States Supreme Court has said double jeopardy clause affords three basic protection. It protects against a second prosecution for the same offense after acquittal. We don't have that here. It protects against a second prosecution for the same offense after conviction. We don't have that here. And it protects against multiple punishments for the same offense, and we don't have that here either.
What do you think we should allow the state to retry? Another non-existent crime? I mean, I guess that's my question. There were no lesser included offenses in this case, and the charged crime was a non-existent crime. What does the state get to retry?
Well, the jury found in the elements of lewd act on a child which was, let me see exactly what the instruction was on that, because it was...
The third-degree felony, lewd act on a child?
No, the 1999 offense, lewd act on a child, that they were instructed on. So that's the two elements of the victim was under the age of 16, and he committed a lewd act upon her, which I believe the allegation in the information was he rubbed his penis against her leg.
Right.
So he was never been acquitted.
You want to retry that and allege the age element?
Yes, because he's never been acquitted of any of that conduct. And I think that's what double jeopardy goes to, is if a jury's acquitted him of any of the conduct. It's just like any case where there's error. You send it back for a retrial unless something bars the retrial. And I don't think in this case, where he was not acquitted of any of these elements, that double jeopardy bars a retrial. And that's my argument. So I would ask this court to remand it for a retrial on whatever offense, and then they can argue below whether he's been acquitted of.
Let me ask you, since you have some more time, defense counsel indicated that we should remand for sentencing on what was apparently charged and what was proved at trial, which is unnatural and lascivious act, a second-degree misdemeanor. How do you respond to that argument?
Well, first off, it kind of runs contrary to his argument that you can't do anything, but, and second, I think if you were going to remand for something like that, they also proved all the elements of the third-degree felony, lewd and lascivious molestation, I think. It's, yes, the defendant has to either be over 18 or under 18, but clearly the defendant has an age. So just charging someone is... You're charging them, so even the third-degree felony for the lower age than the second-degree felony for the older age, I think would be more appropriate than the misdemeanor.
Okay.
Thank you.
Just briefly, the state makes the argument that the charges can be amended at any time. Well, I would respectfully disagree. A charge cannot be amended after a jury's returned a verdict. If this was a case of a theft, and the state proved that only charged a misdemeanor petty theft, went through all the trial, and established the value was at $1,000, and then after a jury returned a verdict goes, oh, judge, we meant to charge this as grand theft, we'd like to amend the information, they wouldn't be allowed to, because jeopardy would have attached, the jury would have already returned a verdict. The Florida Supreme Court has held that age is a necessary element of an offense under 800.04. So the argument they just made of third-degree lewd and lascivious molestation, because everyone has an age, doesn't apply either because no age was alleged. Therefore, that is not a proper remedy. If you go on their argument of it can go remanded for anything of a new trial. The only thing properly alleged in the information, and I do concede this, is the unnatural and lascivious act. That is the only reason I said that is there, is because it is properly charged. There were allegations and proof at trial to support that. Otherwise, it should be a flat-out acquittal, and I thank you for your time.
Thank you.